The key takeaways for me from the back-to-back oral arguments at the United States Supreme Court this week is that the MAGA 6 are in full control and that the Democrats have to get back into power in order to change law and statutes that the Supreme Court is using to take away your right to vote and to undermine a dignified path to citizenship or legal status for those seeking asylum in the United States. Two back-to-back cases. The good news, the silver lining, I guess, about the cases is that they're not fundamentally about the Constitution, where the Supreme Court is the ultimate arbiter of the Constitution. They're about statutes created by Congress. One created in 1845 and the other created at some other time. But that means the Congress can fix what the Supreme Court just broke if the Democrats get back into power about mail-in balloting and about immigration. I'll cover it here. I'm Michael Popok. You're on the MeidasTouch Network and on Legal AF. Take a moment and hit the free subscribe button on both channels. Okay, let's talk about this week's oral argument. It kicked off with a case about mail-in ballots and a grace period that most states give you so that your ballot, once you cast it, you elect and mark your ballot by Election Day. It can take an extra amount of days to be delivered by the mail system. And therefore, places like Mississippi, of all places, and 29 other states give you X amount of business days or regular days to have your ballot arrive and still be counted as long as it was cast marked by Election Day. Seems legitimate. Have you mailed a letter lately and timed how long it takes to end up at your intended location? It takes a fair amount of time. I'm not even sure if 5 business days is enough. But in any event, that is up for a discussion at the oral argument at the Supreme Court, because there is a 1845 series of laws that define when Election Day is. And their argument for the Republican National Committee, yes, Trump and the RNC want to take your vote away, was that, Election Day is Election Day. Things can't come in after Election Day. That did lead to an interesting debate at one point, although I think it's academic and it's not going to drive the ultimate opinion of the MAGA 6, where Amy Coney Barrett and John Roberts were both like, I don't understand your position about Election Day, RNC, Republican National Committee, because we have early voting. Do you want to take away early voting? And they said, no, we don't want to take away early voting. They said, well, that's not on Election Day either. And I thought, well, wait a minute, maybe Roberts and Amy Coney Barrett can get some sort of momentum going here on the dais, on the bench about this Election Day rule, and they'll toss it. No. By the time that 2-hour oral argument was over, and we have a feed of it up on Legal AF YouTube channel, it's pretty clear to me that there were at least 5, if not 6 votes to declare that a state cannot extend the time to accept ballots. Even if they're marked by Election Day, they got to be in by Election Day. That, I think, is going to be the new law, subject to a statutory law change by Congress in the future, which could happen if the Democrats get back into power. That's the silver lining. I guess the best I can say is they're not basing their analysis on the Constitution, for which they are the prime arbiter. They're basing it on statutes, which are congressionally made and can be congressionally fixed. Okay. So that's what I think is going to happen there. We're going to get the ruling by June. We're coming into the final moments, the last throes of the Supreme Court for this term. Usually they finish oral argument by mid-April. They start issuing their decisions for the end of the year, and by June 15th or so, all their decisions are out. That will be enough time for the midterm in November and, of course, for the 2028 election. If the midterm goes in the direction of the Democrats and they get the House and the Senate, then they can fix what the Supreme Court just broke as it relates to mail-in ballots. And they can declare that mail-in ballots are ballots that are cast marked, elected by Election Day, even if they're received up to 5 to 7 business days later. So if you're thinking like, why do I want to vote Democrat? And you're interested in voting, that would be a very good reason. Now let me switch gears. The very next day, they held oral argument in a case brought by an immigration rights group and led by the American Civil Liberties Union, our friends here on Legal AF. And this was about amnesty. All right. And amnesty is a part of our immigration program, or had been for years, in which somebody who's being persecuted in their country, including threatened with death and violence, can seek refugee status or asylum here. I said amnesty, I meant asylum. Can seek asylum here in the United States. We have a program for it. The statute, back to what Congress creates, a law, refers to you being able to apply for this asylum, but you have to be located in or near the United States. If you're in the United States already, somehow you got your way in, or you're here on a tourist visa, business visa, you overstayed a visa, even if you're illegal, but you're in the United States, you can go through an amnesty program, an asylum program, and it can be vetted, and then we have a whole program around it and experts around it. You may be granted it, you may not be granted it. That's if you're in the United States. The question for the Supreme Court was, what happens when you don't get your foot on U.S. soil? Very interesting that they're talking about U.S. soil. I'll talk about that next with birthright citizenship. And they can't get their foot on U.S. soil because the United States is blocking them, for instance, at the southern border and keeping them on the Mexican side. So the Mexican side, if you come to a port of entry into America, you're being blocked from actually entering America and U.S. soil by a border patrol. And if you can't get your foot on dry U.S. land or on U.S. territory, then the argument raised by the Trump administration was you can't apply. You can't even apply because you can't even get in. Now, there is an interpretation of the statute, and this was what the American Civil Liberties Union argued, which was if you present yourself at the front door of the United States, even if that front door is in Mexico, you have arrived in the United States. It's someone who has arrived in the United States. It's this whole term of arrival. And their argument for the Trump side is, no, you haven't arrived because you're not inside. You can't arrive and be in Mexico, for instance, at the same time. But the counter argument to that is, well, then why do you need two provisions? Why is there a provision for you're physically in the United States and then you've arrived in the United States, if it doesn't mean you've made your effort to get to the front door, regardless of where that front door is, and that's enough? You've indicated your intention to apply for asylum. And so this went on and on. It was very clear that the 6 members of the Supreme Court who are MAGA right were not buying the argument about arrival, nor that why do you need two provisions? In other words, you have to give, under statutory construction and interpretation, you have to give meaning to both provisions. And then what does the other one mean? And then there's this perverse flip side to the story where it sounds like you're rewarding people who come in illegally. So if you swim the Rio Grande, which people do, just desperate to come to America, or they used to before Trump anyway, and you get your way in, boom, now you can apply for asylum. But if you knock on the front door, you come in the front, not the back, you're not allowed. It's just perverted. Perversion of justice, we call it. But I think that's what's going to happen. Again, the silver lining, this is not a constitutional interpretation. The Supreme Court does two basic things. It interprets the Constitution where the Constitution is implicated and is the final arbiter about what the Constitution means or says, at least that combination of 9 justices at any given moment in the majority and 5 in the majority. They also interpret federal law. That's statutes, law created by the Congress. If it's an executive order by the president, they determine whether that is consistent with either a statutory power given by Congress, or the Constitution. So sometimes a case in front of the Supreme Court can implicate both statutes and the Constitution. Here, the two cases I'm talking about are really statutory. So the good news is the next Congress at the midterms can fix this problem. Both cases. So that's another incentive for people to vote in their interests about mail-in balloting and about immigration. Final interesting point. In April, we're going to hear an oral argument, and maybe the final oral argument, about birthright citizenship. Also, live feed of the oral argument with my commentary will be up on Legal AF YouTube channel. In that April oral argument, Trump is arguing that the 14th Amendment doesn't say what it says. The 14th Amendment, which says that if you are born on U.S. soil, you are an American citizen, subject to the laws there too. No, to Donald Trump, that's only for newly freed slaves and doesn't include people who are illegally here, or one or both of their parents don't have proper legal status. Then that child is the subject of what country? So they're born in a U.S. hospital or in a U.S. street or back alley or car, and this child is nationless. He come out. You're Guatemalan. I'm Guatemalan. I was born here. I mean, the baby has no connection to his parents, maybe one or two countries. He's just stateless. What's he going to do? Live at the airport like Tom Hanks in that movie? So they're big on getting that foot on dry land, right? Getting that foot on U.S. territory. When you're born into the air of the United States, you are an American under the 14th Amendment. Donald Trump's executive order from the first day of his administration tried to rewrite birthright citizenship and change the Constitution by way of an interpretation in his executive order. So if they're so hung up, as they were yesterday in the oral argument about amnesty and asylum, if they were so hung up on, you got to make your way into the United States to get the benefits of this program, well, then how are they going to deny a baby citizenship born in the United States? He made it, right? He's physically located in the United States as the statute goes. He's arrived literally. It's called an arrival. I tell close family members about when we had our daughter 2 years ago. Of course, I was in the delivery room, and there was monitors for my wife and the baby. I looked up at the monitor about, maybe 6 or 7 hours before my wife gave birth. And I see, because they don't want to give names to the babies. I guess it's bad luck at that moment. So they had up there my wife's vitals, and then they had it for the baby. And on top of the baby, it said Popok pending. Yeah, it's a pending Popok. It's not here yet. It's about to arrive. So I think they've tied themselves up in a little bit of a knot from oral argument to oral argument. And this will help with birthright citizenship to make sure that if a baby's born here, regardless of his parents' status, they are American citizens. And that's what we want in our country. And that's all of North America, by the way, and South America basically does the same thing. So until my next report, you're here on MeidasTouch and Legal AF. Hit the free subscribe button on Meidas. Hit the free subscribe button on Legal AF. And until my next report, this is Michael. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.